Ms. McFadden, you're representing her, correct?
That's correct, Judge.
Okay, so she appears by Zoom with counsel. And Mr. Frank Douglas Aaron is self-represented. Is that correct, Mr. Frank?
Yes, ma'am. Yes,
All right.
ma'am.
All right. I did notice there was a notice of hearing and this was originally calendared as a default, which usually means that the other side has not responded. You haven't filed an answer, so technically you are in default, but I also wasn't finding, well, I guess there's a return of service here. You live in Baldwin. Okay.
Currently, I'm in Missouri. Right now, I'm in Baldwin at my dad's.
Okay. Have you seen proposed journal entry and decree of divorce?
No, ma'am.
Okay. So this is a six-year marriage, no minor children.
No, it was much longer than that. We were married in 2009.
Oh, yeah, it wasn't 19. I'm sorry. So a lengthy marriage with no children.
Yes, ma'am.
Yep.
Okay, Ms. McFadden, are there any issues? I'm not sure that I saw any real estate.
There's not, Judge, no.
And are you not working, Mr. Frank?
Not at this time.
Okay, so it is a 16-year marriage, but no children, no real estate, and probably no spousal support.
No, ma'am.
That is correct, Judge.
Okay. So it's basically just getting the two divorced. How long have you been separate? How long have they been separated?
Oh, for a year.
Okay. Do they have any joint debt?
Yes, ma'am.
Excuse me, Judge, in our prepared journal entry, the debt that we've listed that my client will be taking on will be for Resurgent Capital in the amount of $866. MCI Communication in the amount of $783. LVNV Funding in the amount of $635. Jefferson Capital System in the amount of $591, and then any other debts it had since separation. The debts we listed for Mr. Frank are for a title max loan that he has. I don't know the balance of that, and then any debts he has since separation.
Okay, so she's taking the majority of the debt.
She is, Judge.
Okay,
Your Honor, can I say something?
sure.
We both took out that title loan. The title is in her name too, and her name is on that title. And I don't feel like I should have to cover the whole entire thing when she spent half the money too.
Well, how much is it?
I do not know. I've been trying to call and get a hold of them to figure that out, and they won't return my phone calls.
Okay.
They
Well,
haven't even, I told them where the car is. They haven't even tried to come repo the car.
okay. Well, I mean, she's taking almost $3,000 worth of other debt that you should pay 50%.
That was all
of.
her debt she had before we got
It
married.
doesn't matter.
No,
If
Your
it's
Honor.
acquired during the
debt-
marriage, it doesn't matter whose name it's in.
The
And this-
debt that I'm taking, Your Honor, is credit cards, and I carried most of the job throughout the whole entire marriage.
All right, well,
and
hang
I
on.
also
Okay,
had-
hang on,
okay.
hang on. You're represented, so here's what we're gonna do. We're gonna reconvene because Mr. Frank, you never contacted Ms. McFadden about any of this, did you?
No, ma'am, I didn't know I had to. I just got a letter saying I had a court date, and I needed to show up. That's the only letter I've received.
Did you read the summons?
It just said you need to be here. The letter I got in the mail is from Kansas Legal Service. It says you need to be at this court date at this time.
Okay, so I have a return of service where you were served on April 21st. And the summons says 21 days after you need to file an answer.
I must have read that wrong if I did, and I apologize.
Okay,
I'll take all the I don't care. I just want this over with. I just would like a few things back, like my fishing stuff, my tools, my dad's
okay,
bed.
let me explain how this works. First of all, I've been pretty informal, pretty lax in letting you all just chime in when there's an attorney involved. That's the attorneys do the speaking. Mr. Frank, you don't have an attorney. But the situation is this: either divorces are agreed upon and a submission of a journal entry and decree of divorce is sent to the court where it's by agreement of the parties, or if one party doesn't answer or appear, it can be by default, or we go to trial. So I can't have you sitting here just arguing back and forth and make a decision when it's not an evidentiary hearing and force anything. So
Okay.
what I was going to say is Ms. McFadden could send you a copy of the proposed journal entry of decree. And if you don't agree with something, you can let her know and she'll let Tanya know. Here's what he'll agree to, here's what he won't. She will either agree to modify it as you requested, or she'll tell you, no, we aren't going to. And she will call me and schedule it for trial where you both will have to appear in the courtroom and there'll have to be an evidentiary hearing and then I'll have to make a ruling.
Okay, we can do
That's
that.
how the process works. It's not like Judge Judy, okay?
Yes, ma'am.
Seems like it sometimes, but it's not, and in all fairness. So I didn't start out explaining the process to you very well. And sometimes I can make these things work and pull them together and get them taken care of, and sometimes we can't. But if there's personal property that's unaccounted for and there are things that are at issue, then I need to have those resolved first, or I schedule the case for trial. It's preferable that you come to an agreement.
Yes, ma'am.
So generally when people are paying attorney's fees, it's wiser for them to agree to minor personal property like fishing stuff than it is to pay an attorney to keep fighting on their behalf. I'm pretty sure you can resolve this. I won't set it out too far, but Mr. Frank, you have to just do an answer with the case caption, say denied or agreed, and file it. I'm going to note your appearance. As you well know, Ms. McFadden, default judgments are not preferred in the state of Kansas. So even though he didn't file an answer, I'm going to let him file an answer out of time. I'm going to note his appearance today. I'm, obviously not going to grant the divorce by default. I'm going to ask that you forward him a copy of the proposed journal entry. He either signs off on it or he can email back to you what he'd like in it. And then you guys could see if you can confer and come to an agreement. I would take some testimony from your client today as far as incompatibility and jurisdictional requirements, so that if they sign off on it, we wouldn't have to have another hearing.
Okay, that would be preferred. Yes, thank you.
Okay, all right. Ms. Frank, if you'd raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Okay, so just residency, incompatibility, the fact that whether they have debt, not any assets, not
Thank you, Judge.
length of the marriage, just the generalities.
Thank you, Judge.
Uh-huh.
Okay, Tanya, will you please state your name for the record?
Tanya Lynette Frank.
In this action, are you the petitioner in this action?
Yes, ma'am.
Okay. How are you currently a resident of Kansas?
No, ma'am.
Okay. When we filed this divorce, at that time, had you been a resident of Kansas for more than 60 days?
Yes, ma'am.
And when did you leave the state of Kansas?
The 12th or the 15th, something like that, of September.
Okay, so recently.
Yes, ma'am.
Okay. Are you currently married?
No, ma'am. Well, I'm married to Doug Frank, yes.
Okay, but
Sorry.
you guys are separated, correct?
Yes, ma'am.
Okay. When did you separate?
I think it was August or September of last year when I served him with a PFA.
Okay, so that would have been 2024?
Yes, ma'am.
Okay. Are you unable to live together?
Yes, ma'am.
Is there any chance of reconciliation?
No, ma'am.
Do you believe you two are incompatible?
Very much so.
Okay. Do you own any real property with him?
No. No.
Okay. Is there any personal property of his that you still have?
No.
Does he have any personal property of yours that you would like back?
Yes.
What is that?
My iPhone. And he's got my license plate on his car that he speaks of.
Okay. Anything else?
No, ma'am.
Okay. Earlier, you heard me go over a recitation of the debts. Was that an accurate recitation of the debts?
Yes, ma'am.
Okay. Are you asking this court to hold each of you personally responsible for your own debts
Yes, ma'am.
as laid out earlier in the hearing, correct?
Yes, ma'am.
Okay. Have you had a chance to review the journal entry and decree of divorce?
Yes, ma'am.
Okay. Do you believe it's fair and equitable?
Yes, ma'am.
Okay, thank you. No further questions, Judge.
Okay. In a very civil manner, Mr. Frank, do you have any questions of this witness?
No, ma'am.
All right. Okay, so again, we're gonna adjourn. Mr. Frank, Ms. McFadden needs your email. They don't usually do a lot by phone because it's when people are unrepresented. They just wants documentation of
Okay. How long are you
of
gonna give me?
conversation.
How
Huh?
long am I gonna have? Because I'll probably get a lawyer before then. I'm gonna actually go get one probably today, but I just want to know how much time I'm gonna have.
Well, I actually wasn't going to set it for another hearing, but I can. It'd probably be 30 days. You either
mean,
have
I
an
think-
agreement or you'll have a lawyer and we'll schedule it for trial.
Yes, ma'am, I can do that.
All right. I would suggest you look at the journal entry first and confer. If you're unemployed, listen, I can't give you legal advice, but if you're unemployed and you're going to a fast loan place and giving them a title to a vehicle to get money at a high interest rate because you don't even have any money, it seems like to me it'd be better to pay off the debt than go spend a couple $1,000s or more on an attorney. But you do what you want to. But
Yes,
I
ma'am.
think that you ought to look at the proposed journal entry and you ought to make an effort to resolve the matter. And if it's resolved quickly and you sign off on it, I will sign off on it. If it's not, then, it's going to postpone everything, or I may bifurcate the divorce and give her a divorce because she's entitled to a divorce in a no fault state, but reserve all the property issues, which means you're still tied up in court. But I will give you a court date in 30 days. That's what you desire, and you decide how you want to proceed. And if you want to hire an attorney, you're more than welcome to.
Yes,
All
ma'am.
right, October. Well, that isn't 30 days, so. Today is 29th. It's not gonna quite be 30 days, otherwise. Well, Ms. McFerrin, I can give you October 27th or November 6th.
What time on the 6th, Judge?
On the 6th, I have 9:30, 10, 10:30.
Can we do 9:30, Judge? On the
Yeah,
6th?
that'd be great. That would be great. All right, so.
And then
put
I'm
this
sorry, Judge.
down. Huh?
Mr. Frank, can I get your email address, please?
DOUG
Uh-huh.
dot
Mhm.
FRANCQ@gmail.
Okay, I'll email you.
All right, thank you.
Of course.
Okay, so nothing in person yet. I'll reschedule it for Zoom on 11/6 at 9:30 AM, just as we're doing here. And you can announce to me at that time. You know, an attorney will have entered by then if you're gonna have one, and the attorneys can make an announcement to me, or if it's not resolved, I can schedule it for trial. Or if you resolve it before that date and you sign off on the decree, then she will upload it and e-file it, and I will approve it. And
Yes,
the
ma'am.
divorce will happen that way without another hearing. Okay?
Yes, ma'am. When I log back in, do I just use the same login stuff?
Amy, I'll let you address that. I'm not sure. I'm sorry.
Okay.
Okay, I'm gonna step out of here and she can let you know that information. Of course, Ms. McFerrin, you and your client are free to go.
Thank you, Judge.
Thank you.
Thank you.
Bye-bye.
Have a good day.